very fortunate to have so many of our candidates who are able to join us this year. Every year, every 2 years when we have these meetings, we talk about the importance of the judiciary and the importance that these kind of meetings play in getting the information out about candidates and raising some profile for these races. That's particularly true this year. The ballot will be very crowded, and we owe it as lawyers to do our part to make sure that the public knows about these races and knows the men and women who have offered themselves as candidates here. This is not something that most of us choose to do. It is a service that these ladies and gentlemen have undertaken, and we appreciate their willingness to put themselves forward and to go through processes like this. So we thank all the candidates, and thank you particularly for showing up here today to be with us. We will start with the seat for the North Carolina Supreme Court. This is the Brady seat. The questions were given to the candidates in advance. I will read them to you again, though, now. Pursuant to the North Carolina Rules of Civil Procedure 12, 50, and 56, the court is required to remove cases from the jury when justified by law and the evidence, regardless of the consequences to the parties. But many trial judges appear reluctant to do so. Following the guidance of the U.S. Supreme Court, federal judges in North Carolina and elsewhere have been increasingly apt to dismiss at the pleading stage those cases offering no plausible argument for merit, and many federal cases are dismissed or pared down by summary judgment upon the conclusion of the discovery. Is it time to follow the federal example and give our trial courts guidance and encouragement to enable them to properly weed out or to narrow appropriate cases? And the question will be answered by Judge Bob Hunter and Judge Barbara Jackson. We're going to go in alphabetical order, so Judge Hunter will address first, and then Judge Jackson. Bonnie Rafinsky is keeping our time down here. She'll give you a 1-minute warning, and then we'll stop you. Judge Hunter.
Thank you, David. I assume that the 5 minutes is not just to cover that question, but to talk about ourselves and why we think we're qualified to ask for your support in this election. And first of all, let me say I thank you for your endorsement very much. I've been blessed in this race, and I've had the endorsement of every major group that I know of that's endorsed, so I certainly appreciate that. I enjoyed being with y'all at Hilton Head, and it's a special pleasure for me to be here today for a couple reasons, one of which, and I didn't know about it, is my good buddy from Marion, Charles Bergen, just receiving that award. Charles, it's really great to see you get that, because you certainly deserve it. I've practiced with him for 29 years in the same town, and I know what kind of quality person he is, and Bunny equally. And also, he's helping me in my campaign, so I appreciate that too, Charlie. The other reason it's a pleasure is I get to see my daughter today, I hope, maybe even sit beside her at lunch, although usually I try to sit beside people I don't know when you're running in an election. But my daughter is here today. I was blessed and proud to swear her in, I think 3 weeks ago, and she is now practicing in Raleigh with Yates, McLam, and Wire. So, Claire, good to see you, and we'll get to spend a little time together, I hope. I'm very, very proud of you. Let me talk a minute about my background and try to get into that question a little bit. I've practiced law for, it's not quite correct in the bulletin, from 1969 to 1998 when I went on the Court of Appeals. So it's 29 years, Zog. And during that period of time, I think I gained an appreciation for what it's like to practice law. And I did some plaintiff's work, but I had a significant amount of business practice as well, Steve. And and I was county attorney for 24 years. I was in the legislature where we had to deal with significant business issues. Matter of fact, those of you who are LLCs or anything along that line, that was the legislation that I sponsored in the General Assembly. And I sure was thankful to have some very qualified lawyers and CPAs who knew a lot about that bill when we did it, because at that time it was very new, and it was something that was very much needed in the state. I also was involved in some small businesses as well. So I think I know from a business perspective, from a defense perspective, what you face. I've been on the court for 12 years, heard 3,600 cases, I think, written about 1,200 opinions. I hope you liked most of them. I'm sure there's some that you didn't. But I'm sure on the other side, from the plaintiff's bar, the same way. That's why I'm most appreciative to have the endorsement of both groups and the endorsements of people like some public defenders as well as DAs and law enforcement groups and teachers and women attorneys and others. But I hope that means that they trust me. They trust me to be fair, that they think I'm fair and balanced and a good judge or a fair judge, because that's what I work hard at trying to be. And that's what I've tried to do on the Court of Appeals and what I will take to the Supreme Court if you and others are kind to me. And I'd love for you to be as kind to me as you were in 2006 when I visited all 100 counties and I carried 99 of them. But